next speaker is Justice Marc. He's in trial court and appellate court. Please welcome Justice.
Thank you all very much for having me here. It's good to see so many familiar faces. I often say it's good to see anybody in my life. The Board of Appeals is kind of like the big fair business. It's a lonely place. So, Marc, I've asked you to talk about trials versus appeals and some practical considerations from both ends of the spectrum. So that's what we're going to talk about. I'm slated to have an hour. I promise I'll give you some of that time back. I'll certainly take questions at the end. So, trials versus appeals. This is the trial court. We see it every day here in Harris County. What they all look like, one size fits all. This is the Court of Appeals. All right. No difference at all. No difference at all. All right. Court of Appeals is young ladies work, the drinking fountains work, you can take the stairs. There are lines around the building and the alarms do not go off at random. You ever think about the elevators working? Yes, they work, all two of them. All right. So, there really is a difference between trial practice and appellate practice. Some of you do both, and you have some concept of what those differences are. Some of you do primarily appeals, some of you do primarily trial work. So perhaps you don't really understand the full difference between the two. So, we all know that a trial practice is very different from an appellate practice. All right? One, you do most of your appellate practice behind the desk, or in a lounge chair, or in a lazy boy, or someplace more comfortable than in the courtroom. So the setting is different. Most of your trial cases settle, either by plea or dismissal. Some of your trials even end in an acquittal. If there's an acquittal, there's no appeal, I don't get the work. It's very rare for a case to settle once it's appealed. We have some where the appeals are withdrawn. We have some where the appeal was not properly expected. But generally, appeals do not settle. Trials happen very quickly. In most courts. In most courts. Those of you that were in front of me back in when I was on 180 know that by the end of my tenure there, I could get you a trial date in about 4 to 6 weeks. Once you have the court. So you need to be sure that that was what you really wanted. Now I know there are some courts with the digits 209 in them that might not get the trial as fast. And I understand that as well. But appeals never happen quickly. Appeals take forever. And that's the nature of the beast. Why do appeals take forever? Well, I can tell you that for you. Over across the street at 1st and the 14th, unlike the Texas Supreme Court and unlike the CCA, we can't say no. We have to say yes to everything. So, we get everything that is appealed, whether it's a righteous appeal or not. We have to take it. We have no discretion in that matter unless there's some technical glitch that keeps it from being professional. And the two courts combined last year did, and the first year I was on the bench, well, I can tell you what the 14th did the first year I was on the bench. We handled just over 900 cases. And so that's about 100 cases per justice that we dealt with and disposed of in that 1 year period. So we got plenty to do. The other thing from a personal standpoint, aside from the fact that it's very lonely in that building, you don't get to see people a lot, is that when you're on the trial bench and all of your cases work out, or your trial is over, you're done for the day. You can go home. Over there, there's always something else to do. Because there's another case that's waiting for you to read the oh so exciting brief on with regard to a summary judgment on a novel. So there's always something else to do over there. Well, let's talk about the road to the appeal. Or, better yet, let's look at one of my favorite lines in classic rock. Well, how did I get here? In the appellate process. Well, let's look at the backstory. How did the case get to the Court of Appeals, or how is the case going to get to the Court of Appeals? Was there a plea? You know, if there's a plea, that generally is a roadblock to getting your case up to the Court of Appeals. There are some situations, of course, where we know that is not the case, but generally, if it's an agreed plea with a plea bargain, generally the case isn't going to come to me across the street. So, was there a plea bargain? Was there testimony? But here's the kicker. Were there contested issues raised by pretrial motions and heard on the record prior to the plea? That'll get you in front of us across the street if that happens. But it will only get you in front of us if this certificate of appealability is correctly filled out. Alright? Now, you all go through all that paperwork with your client. I know how it works. And I know you've got judges who say, we've got a jury in the hallway, we need to get this plea taken, let's hurry up, let's hurry up, let's hurry up. And so sometimes that certificate of appealability box gets checked wrong. So then we have to remand it to see if it's right, or we look at it and go, well, based on what's checked and what we have in the record, you don't get to appeal this case. So, it seems like a really little thing, but make sure that that certificate of appealability is properly filled out. Because if it doesn't, that makes the process take even longer than it does in its normally slow course. Pretrial motions, or as I like to call it, motion sickness. And some days they really do make you sick as a trial judge. Let me confess this, all right? You've got the situation where, especially on the motions for discovery, generally aren't needed because most courts do the agreed discovery order now. Plus, you've got mandated discovery under the Marc warning. So, the motions for discovery aren't quite as important as they used to be, but there are some times when you need specific stuff that those things don't cover. I totally get that, and you should certainly file those. But do you really want to file a motion for ballistics testing on a dope when there is no gun? I tell that all the time. Or do you want to file that motion to suppress the illegal warrantless search of your client when there was a search warrant? You know, just examples of when the motions actually might make the trial judge sick. All right? Pretrial motions. I moved a little bit. Remember this, folks, especially for purposes of the appellate record. Just because you filed the pretrial motion does not mean you requested a ruling on it. It does not mean that. Your trial court judges are not Karnak. They can't say, oh, I think there's a motion here that I need to rule on. It's not going to happen. And of course, part of that means you need to remember what you filed in that case. Okay? What pretrial motions did you file? We talked about discovery. Suppression. What are you trying to suppress? Let's be specific if you can. Watch the indictment. Other pretrial motions. But again, let me stress this bottom point here. Please, 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 let the trial court know that you want a ruling on these motions before the advance of the panel coming in the doorway. I see Judge Reagan shaking her head here. She must have seen that once or twice during her tenure on the bench. It just doesn't make things go smoothly. And it doesn't endear you to the trial court, I can tell you that from personal experience. Was there a trial? All right, on the way to this appeal that we're headed toward. Well, was it a court trial? Sometimes you want a court trial. Sometimes a court trial is a slow people play or guilty. It really just depends on what you got in mind. All right? Was it a jury trial? If it's a misdemeanor jury trial, what all do you want to put on the record? You want voir dire on the record? It's not automatic on a misdemeanor jury trial. If you don't have voir dire on the record in a misdemeanor jury trial, have you waived all of your voir dire errors? You bet. If it's not there, we can't look at it. Again, one of the contested issues raised by pretrial motions and heard on the record prior to or even in the middle of trial. If there were, make sure that the court reporter has all of that record transcribed. Did you put everything on the record that you need to? Did you put everything on the record that you needed to? Objection. Overruled. Judge, I'd like to make a bill. We'll do that outside the presence of the jury at a later time. remember to do it. Well, do what I do. Write yourself a note. I'd forget my own name if it wasn't written down on my door every day. You know, those senior moments comes more and more frequently. So just make yourself a note. Write it in red, highlight it in orange, I don't care. But just figure out somewhere to do it if you want that in the record. Was there a charge conference? Was it on the record? Now, I will say this, and this is just by way of bragging based on where I came from. The records we get from Harris County proceedings are head and shoulders above the records we get from the other 9 counties we service over. So you all should be proud as Harris County practitioners primarily for the work you do in getting us that complete record. There are things we see from out of county where both the state and the defense are just abysmal. And I don't know, there was a recent en banc court argument a while back that was living proof of that if you happen to go over there and see it. It involves out of county players. And one of the people at the beginning confessed that he was no Clarence Carroll. You know what? He wasn't. We conceded that point, sir. He was definitely not. We were definitely not. So, with regard to this charge conference, I know it's human nature for all of the participants to talk informally about the charge. Kind of figure out where we're going. All right? But again, this kind of comes back to making your bill of exception. If there's something that you talked about at the informal charge conference that was off the record, put it on the record at some point prior to the charge being read to the jury. You know, the way I used to do it, we used to huddle up, we'd talk about it, and then I'd go on the record and say, any objections? And I would always try, if there was something that was said at the charge conference that neither side brought up, I would always try to throw that in as well. Do you still wish to urge this? So that the record is complete. Because we don't want to guess, and we can't. So, you know, we get cases sometimes where it looks like the trial court sua sponte put in instructions. You know? That doesn't look great, right? Or, if there are situations where it looks like the defense did not object to a proposed instruction that was clearly harmful. That probably won't really happen. They just didn't do it on the record. So we need to know that. Were any exhibits admitted for the record, but not before the jury? Happens a lot. Happened a whole bunch in the case I tried down in the state of Texas versus Jessica Tata. You might have read about it. So make sure that those exhibits that were not admitted in front of the jury are admitted for purposes of the record on appeal. Make sure that the court reporter has them. Let you in on a little secret. Lawyers who kick off the coordinator in trial courts, judge always knows them. Judge always knows about that. Lawyers who tick off the court reporter, we don't always know about that. But by God, the court reporter. And the court reporter, you want the court reporter to be your friend. You do not want the court reporter to not be your friend or not be happy with you at the time. Were there any items filed under seal with the clerk? Are they in the clerk's file? Second part of that little secret. We never know if the clerks are mad at us. We never know that as problem. But by God, the clerk. And just like with the court reporter, maybe even more so, if the clerk is mad at you, your life really can be a living hell. It is not a good thing. So you've got these things filed under seal, and they're in the clerk's file. Don't just waltz up there and start rummaging through the file. And do not ever just go up and take the file away from her and sit down at the counsel table and start taking it apart. Ooh, I can only imagine what Jolene Hart would have done to you. It would not have been a good thing. But again, think about it in terms of the record as trial court practitioners. Think about everything you do, especially if it's in the trial setting, for purposes of the record and preserving that record. For all the cases that we get, back on those many motions that you filed, One of them was probably a request for findings of fact and conclusions of law. And it might actually be a case where the judge is entitled to or could or maybe has to make them. Well, if it's not mandatory and you want those findings, just filing that motion and letting it sit in the back of the file is not going to be enough to alert the judge that it has to happen. Okay? Not going to be enough. So, if it's not mandatory and you want those findings made, ask. Now, with regard to the mandatory file, in a perfect world, your judge will know that under 3822, those findings have to be made when a statement is admitted. He may forget. I suggest it's probably not a bad idea for you to remind him or her that that has to happen. Because if it doesn't happen, it gets to us, we go through the file, we see that there was a statement made that was admitted, that its admissibility was contested, and there are no written findings, not even any oral findings. Then we're going to make it easy. And that's going to slow things down again. And it really, it just isn't a good thing for anybody for that to happen. 3823. All right. Not mandatory, but were they requested? Did somebody bring this to the attention of the trial court? Did the court, in fact, make such findings, or later writing and sign them? And if he did, are they part of the record? Here's another little practical tip. Always a good idea to submit your own proposed findings of fact. I know it's easier for the PD's office to do that because they have more resources. I get that. But it's always a good idea for you to get your version out there. All right? Because I promise you the state's going to do that. Now, what I would do, typically, is write my own. I always wrote my own with regard to the statement, and I generally wrote my own if it was something else under 3823. Now, there was a big case in the PD's office, and the DA's office fought over some dry language with a detailed minute, and each side submitted approximately 40 pages of proposed findings of fact and conclusions of law. And from that, I put together my own 30-page finding on the state of Texas versus Leroy Code. So that's how it works with the practical matter. But again, I encourage you to submit your proposed findings for the trial court. One, so the trial court can have some notion of what it's about, or what he or she is looking at. And two, power of suggestion. Also might make the trial court rethink some of its positions if it sees that in writing. A lot of folks I know who are on the trial bench will rethink their position. I agree. Again, yeah.
When it's mandatory, is it enough to be oral on the record from the judge, or they have to submit it?
For statements, it has to be written. So, motions for new trial, again, on this road to appeal. Was one filed? They're not always filed. You don't have to file one to get to the appellate court. We know that. If it was filed, was it timely? Was it urged? Did you request a hearing? Was there a hearing? Was it done by testimony or was it done by affidavit? Was it ruled on or was it overruled by operation of law? We have that by testimony affidavit twice. I guess that was really. Is the motion for a new trial proceeding included on the record? One thing about motions for new trial that I'm sure most of you realize, if there is no motion for a new trial, and one of the bases for appeal is ineffective assistance of counsel, that's a tough road to hoe on direct appeal, because there is not going to be much in the record that suggests that it is not proper trial strategy. All right, and I'm not saying that ineffective assistance exists a whole lot out there, especially in Harris County, because I don't think it does. But if there is no motion for new trial, that avenue is precluded generally, although there was a case out there not long ago from the sister court where it was pretty obvious that the counsel was ineffective and there wasn't a motion for new trial. But it was, as we say, painfully obvious. Okay. This is in this building I work in. I see it every day. This is great. All right, so you're over there. You're over there in the court of appeal. Now what? Well, first of all, appellate writing is very, very different very good from motion practice in the trial court. You all know that in the trial court, as trial court practitioners, you've got your standard motion. You may tailor them for each individual case, but you've got your standard boilerplate motion. All right? You've got your standard motion to discover, your standard motion to suppress, your shotgun motion to suppress, put everything in the kitchen sink. And sometimes you file motions in the trial court that don't apply. We've already talked about that. The only boilerplate thing there is in the Court of Appeals is an English brief. All right? No error. There are no standard briefs. The briefs are highly specific, and everything in the brief needs to apply or it should not be in the brief. Totally different. Totally different. The record on appeal. I cannot tell you how many times we get things in front of us where points are raised that are not in the record, outside the record. Maybe they thought they were on the record. Maybe we don't have the whole record. But the record on appeal is crucial. Make sure we have the whole record. Well, how can you do that? Well, if you're the appellate lawyer, you can look at it and see what happened. You can look at the docket sheet and compare. Looks like there was a hearing on a motion for a new trial. By God, that's not with the record. We better get that. All right. Looks like there's a pretrial motion to suppress on the record. That doesn't seem to be with the trial court record that's in the clerk's office. Maybe we better make sure that's there. All right. But again, if we have the whole record, please don't argue something that's not in it. Because you think I'm a smart aleck, and I am. There's some people over there that put me to shame. So if you stand in front of them and argue something that's not in the record, they're not going to like come off the bench and hit you or anything, but you're going to kind of slink out of there and go, ooh, I didn't get it. So it's just better. It's just better. All right, trial attorneys. Try and give the appellate lawyer something to work with. Okay? Really. Try to do that, all right? Make a good record. Preserve your potential points of error and try to avoid waiver. You know? There are some panels in that building that love waivers. And it's the best exit slice. Oh, wait. So, try to avoid that. Trial attorneys who have an exclusive trial practice. Read some appellate briefs. Help out with appeals. If you really want to get an education, go attend some oral arguments. If you can stay right through them, they can be pretty interesting. Appellate attorney. Talk to the trial lawyer. The trial lawyer was there. He sat through the whole thing, whether it was 3 hours or 3 weeks. He knows, and I use that term generally, he or she knows what happened, all right? Review the entire reporter's record. Again, that goes back to making sure you have the whole. Review the entire clerk's record. I know it's about as exciting as looking at dry paint, but make sure that you know what's in there. If you can get trial counsel's, or look at trial counsel's case file, look at that. Appellate lawyers attend some pre-trial evidentiary hearings. Understand what's going on in the trenches, as opposed to looking at that cold record. And attend some jury trials. 6 seconds. Some jury trials with some trial lawyers. You can learn a whole lot and get a whole different flavor from what was going on in the trial rather than looking at a cold appellate record. Now, Fred still asked about this, and I said, I'm going to talk about this. Oral argument. For you appellate practitioners, does oral argument matter? Yes, it does. I ask for oral argument a lot, mainly because it's an excuse to see people. But aside from that, generally there are 1 or 2 issues that might need to be fleshed out, or that might be close call. And so it's on issues like that where I want to have somebody talk to me about it, one-on-one. And of course, the beauty of it is, unlike when you're making jury argument, we get to ask questions. Keisha had one a while back, and I got to ask her some questions, and it was tons of fun. It was tons of fun. By the way, you did an outstanding. You did absolutely outstanding. All right. But yes, oral argument does matter. My theory is, if it doesn't matter, then why do we have it? So absolutely it matters. When you're filing your brief, include a request on the cover for it, include a statement regarding the oral argument in the brief,
If you want it to be conditional, that's fine. And you know, there are some cases, obviously, where you do not need it. But most of the time, it probably wouldn't hurt, right? Now, some people file these motions to reconsider granting oral argument. That generally doesn't go over well, but you gotta understand. I totally get it. Now, I will tell you, we had a situation a while back where I had granted oral argument on a case. It was my vote, and it was gonna be my case. And people said, well, that's great, but we can't come that day. And I said, well, that's great. Submit it on the brief. We won't reset it. We just won't hear it. And would you believe they were actually able to make it after all? Wow. Funny how that worked. They just wanted it later as opposed to soon. So, all right. Preparation. And this is actually true at the trial level as well. Okay? Know your court's procedures. Know your court's procedures at the appellate level. Know your court's procedures at the trial level. Those of you that tried cases in front of me on the 180, you knew what my pet peeves were. You knew how I did my challenges for cause at the time. You knew how that worked. All right? So, at the trial or appellate level, know your court's procedures. Know your judges. Again, you got 37 criminal judges here in Harris County with 37 different personalities. I'm sure you all have horror stories about all 37 of them. I'm sure you have horror stories about me. I understand that. I expect that. All right? Same thing over at the Court of Appeals. There are 18 judges over in that building, so you've got 18 personalities who then have to interact with 17 other people sometimes, depending on the configuration of the panels and all that. Know your record. That goes back to make sure you have the whole record.